My lord, I get to mention item 35, my lord.
35.
Here, my lord, respondent number 5, who is the Commissioner Transport, my lord, who has, my lord, issued the order for enhancement of the, my lord, grade pay of all the drivers of the department in Arunachal Pradesh, my lord, and they have not filed the counter affidavit, my lord. If they are not filing, my lord, may I pray that, my lord, records pertaining to that notification dated 29/2016 may be called for, my lord. Because, my lord, the drivers of the civil department matter has been increased, the grade pay matter has been increased, matter pursuant to a matter representation by all the drivers of Arunachal Pradesh seeking, my lord, similar, my lord, grade pay date of, my lord, LDC, matter. That was, my lord, approved by high level, my lord, scrutiny committee, matter. On the basis of the decision of the high level committee, my lord, the pay has been increased, my lord. In my case now, my lord, I am the police driver.
High level committee has recommended your case.
No, my lord. Rejected my case, my lord.
So
That's why, my lord. But, my lord, they have the high level committee, while, my lord, upgrading the grade pay of the driver, has, my lord, drawn
no,
the
they
parity
say
between
that these drivers of other departments they don't have any promotional avenue.
My lord, so in some departments, my lord, there is promotion avenues, my lord. In the name of grades, my lord, grade 1, grade 2.
Yes.
Lordship, in that case, Lordship, I may be able to file affidavit on behalf of Transport Department also.
Transport Department.
Yeah, my friend is senior president.
Okay. Mr. RCK Land Counsel for the petitioners. Considering that the claim of the petitioners is for enhancement of
Grade pay.
grade pay with parity with the drivers of transport department whose grade pay has
Not only transport, all the, my lord, civil drivers.
who is some of the no in that case what I said transfer of other departments the state of Arunachal Pradesh comma Mr. Estafin London Council London Senior Government Advocate is granted 3 weeks time to file affidavit on behalf of
Respondent number 5.
Five, my lord.
respondent number 5,
Five.
i.e.
Transport Department.
Transport Department.
Right.
This after 3 weeks.
May do.
Yes,
I would like to mention item number 31.
31.
Yes, I instructions not to press any further.
31.
30.
Mr. Deepak Land Council for the petitioner submits that he has an instruction not to press this petition. Mr. Therefore, respond disposal of the petition and press for allow him to withdraw the petition. Press allow. Mr. B. Picha, London Council for the London Standing Council
Standing Council.
are the rural development department is present. Writ petition stands close as withdrawn. There is a 31 and 32.
32 will remain.
Huh?
32 will.
Then why this has been listed together?
Is from the same block.
Okay. Okay.
Madam, further item number 5, madam.
Yes.
I understand Mr. Nawam is also not here.
Hmm.
Can it be after the vacation?
This is regarding what?
This is the land, madam.
Allotment.
Yes, department has filed an affidavit in my favor.
Okay, department.
Yes.
How is it's your paper?
Madam, now they have said that earlier order was wrong. They have constituted a committee. They have scrutinized it and says that it's all.
They will scrutinize it.
They have done it.
So
The report is in my favor.
who is for the respondent? In case this,
Because land department had filed earlier, Mr. Kamduk, he's not appearing now.
You can close the matter in that case.
The difficulty is, Mr. Parme has filed an affidavit.
Yes.
Regarding this,
But he has
sir,
not
I have
challenged the
received any
report.
instruction. Regarding this, your lordship, the petitioner has said, I have not received the instruction, your lordship.
No
We have only
instruction.
filed our,
They have already filed an affidavit.
only counter affidavit is with me, your lordship.
Madam, what more you want? You have already filed the affidavit. What instruction you want? Yes, what is your stand?
Here we are saying that, your lordship, that the land, the float of land that the petitioner occupied is this one without allotment order is.
That's
No, no.
that's a history now.
Incorrect, my lord.
That's
on
a
the
history
affidavit
now.
written, your lordship.
That's why. Anyway, when do you
I
want?
better mention because Mr. Nawam is not here. I think
Why
he-
Nabam is required in such a matter?
Oh, there is another thing, but I have him ready. But
Why Mr. Nabam is required here?
actually, yes,
What difficulty was it? Earlier lawsuit, the four lane lawsuit for Mr.
it
Kamduk.
should not be
If
appearing.
there's if there's no standing council,
No,
Can-
we are appearing, but the record we have not received. The affidavit
Yes.
filed by the lane lawsuit.
okay, heard Mr. Deepak learned counsel for the petitioner. Mr. Estafit learned counsel, learned senior government advocate submits that since the matter was dealt with by the learned standing council for the land management department, he may be granted some time to obtain the records from the learned standing council. Praise the Lord. This matter after 3 weeks. 3 weeks.
Well,
Yes.
okay.
May I please, your lordship, my lord? My lord,
Yes.
I'd like to mention item number 14 and 15, my lord.
Yes.
In item 15, my lord, I was supposed to file an affidavit, my lord, and I'm preparing it, my lord. It takes some time, so very voluminous, my lord.
14 and
May-
15.
2 weeks.
Yeah,
14
my
and
lord,
15, my lord.
I appear for the petitioners, my lord. The second petition is identical cause of action to the first. In the first
Okay,
petition,
then we'll grant them
No,
some
my,
time.
my lords will hear me for a minute. In the first petition, he has already filed an affidavit in reply on 6th of December 22. After that, he has taken time on 4 separate occasions to file
It's
this
okay.
affidavit.
It's okay, sir. We'll see.
But my lord,
Unless without the affidavits, it will be difficult. And otherwise also, this is fixed for orders today. All right.
My lord.
On the
would my
prayer of
lords-
Mr. M.K. Boro, learned standing counsel, CBI.
CGST, my lord.
CGST. Learned standing counsel, CGST and CX or CGST. CGST. List this
Central Goods
matter
and
after
Service Tax.
3 weeks. So
My
as
lord-
to enable him to file affidavit in opposition. List of Mr.
My lord.
Mr. Rohan Shah.
R. Rohan Shah, learned senior counsel for the petitioner is present. List after 3
My
weeks.
lords, the interim orders to continue, my lords.
Interim order passed earlier shall continue. Yes,
May I please, my lord?
yes.
My lord, I'd like to mention.
11.
Yes.
Yes.
Yeah, my lord, I intend to file reply, my lord, but I'm not able to get through to the clients. May I pray for some time may be granted.
On the prayer of Mr. D. Shoki, learned counsel for the petitioner. List this matter after 4 weeks so as to enable him to file affidavit in reply.
My lord, I beg to mention item number 27, my lord.
Hmm.
My lord, I may be granted 3 weeks time to file counter affidavit.
On the prayer of Mr. T. Tagum, learned standing counsel, education department, and prayer not being objected to by learned counsel for the petition. List this matter after 3 weeks so as to enable him to file affidavit
Yes, my
in
lord.
opposition. Yes,
My lord, there is interim order.
interim order passed earlier shall continue.
Deeply.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 6. Here, my Lordship has once passed an order not to be listed this matter before my bench of my.
Yes, item number 6,
Yes,
not before this court.
yes.
Ah.
So matter may be listed up back. Obliged.
Lordship, item number 23, Lordship.
22,
23, Lordship, 23.
23.
Yes, Lordship.
Yes.
Lordship, actually, my petitioner, this is my client, that it is not contact. Actually, he's supposed to hand over me one document, but it's out of the contact, Your Honor. So one time may be given here.
On the prayer of Mr. G. Kato, learned counsel to the petitioner for the 3 weeks time is granted to obtain instruction.
Your Honor.
Mayor, my lord, I would like to mention item number 33, my lord.
Yes.
My lord, matter is supposed to fix for filing of affidavit by respondent. Matter is fixed for filing of affidavit.
Item 33.
33.
This is for listed for hearing.
Yes, sir. 33. Hearing. 33. Item number 33.
Yes,
Yes,
it's listed for hearing. We'll hear you.
my lord, the lady for
If they have chosen not to file affidavit, what can we do? We'll hear the matter.
actually, my lord,
Give the second file. Take the second file and prepare.
senior counsel,
We'll take it by 4 o'clock. If you want more time. 2 o'clock or 3 o'clock, 4 o'clock.
but my lord, senior counsel Bjorn did not.
Just give the second file. Go through it. We'll see. Take the second file and read it.
May I, my lord? I beg to mention item number 22. That my lord, my senior counsel has departed for his village due to attend the funeral service of his relative members.
On the ground that Mr. Who has gone?
Entaje. Entaje.
On the ground that Mr. Entaje is in Brisbane, Mr. So-and-so learned counsel appearing on his behalf, praise for listing of praise for adjournment of the matter. Prayers allowed, list after 3 weeks.
My lord, my present may be recorded for respondent 1 to 3. My present may be recorded for respondent 1 to 3.
Mr.
T. Marngar.
T. Mannan.
Yes, my lord, for Nitin Khera.
Huh?
T. Marngar.
Your name is not there?
For Nitin Khera, my lord. For N. Khera.
On behalf of Mr. N. Kera, London Standing Council. Power Grid.
Yes, my lord.
Power Grid is present, huh? You record.
Ali Obliged.
Obliged.
Your Honor, I would like to mention item number 12 and 13. Since the senior counsel is at out of station, and we have consented with the opposite parties, and this matter may be taken up after the vacation, Your Honor. 12 and 13.
Lordship, first week of August, this matter may be taken.
On the prayer of your for respondent.
Yes. Just one.
Your name, please?
Tai Kumar. Tai Kumar. Tai Kumar.
You are appearing on behalf of?
Tadu Bayor. Tadu Bayor.
London Council appearing on behalf of Mr. Tadu Bayor, London Council for the respondent. Submitted phrase for adjournment of the matter on the ground that Mr. T. Bayor, London Council for the respondent is indisposed. Mr. Prayer not being objected to by Mr. I. Bam, London Council for the petitioner. Let this matter be listed. After in the first week of August.
Yes.
2025.
Your Honor, one more, I would like to mention one more unlisted item. I have filed the petition yesterday, but it is not listed today, so I would like to
Why
mention
the urgency?
as an unlisted matter.
What is the urgency?
It is a land matter title suit with compensation under the district of Kurung.
Title suit?
Yes. No, Your Honor. Representation, Your Honor.
Tomorrow.
Representation.
Tomorrow.
Your Honor?
Tomorrow.
Tomorrow, Your Honor. Obliged.
Please come first. Let us finish.
May Your Lordship.
Yes, which item?
Your Lordship, I beg to unlisted matter may be listed for tomorrow, Your Lordship.
Yes, tomorrow.
I,
Your Honor, I'd like to mention item number 1, Your Honor.
1.
Yes, Your Honor.
Yes.
Yes, Your Honor. The nature of the writ petition is is habeas corpus, Your Honor. Nature of the writ petition is habeas corpus, and as per the notification dated 8 June 2022 issued by the
List before the appropriate bench,
Yes, Your Honor.
appropriate division bench.
and maybe listed tomorrow, Your Honor. Tomorrow.
We will list it tomorrow.
Yeah, Your Lordship. Lordship, I beg to mention item number 34, Your Lordship, on behalf of Yomi Riram, Your Lordship. He's in hospital, Your Lordship. He asked me to adjourn this matter after vacation, Your Lordship.
What is the matter?
Service matter, Your Lordship.
We'll no adjournment. We'll take it up. You are appearing for petitioner. Are you ready?
No, Lordship.
Huh?
I have been informed by the government advocate, but he will not take up this matter today.
What is the matter?
Lordship, I don't have the brief. I don't have the brief, so Lordship.
We'll see. You have the brief.
No, Lordship.
Why?
Lordship, my senior has been here to attend this matter. So, Lordship, the government will take adjournment then. Government will take up or adjourn today this matter. So, Lordship, I have been come here.
Without knowing anything.
Yes, Lordship.
Are you taken for granted that if the government wants to, adjourn the matter, the court will be granted. Court will grant the adjournment. Don't take it for granted.
Okay.
Get the file, get hold of the file and go through.
Okay. Oh, bless.
May I, Lordship? May I submit? Your Lordship, through this petition, I'm seeking protection of my land from the illegal construction of boundary wall by the school authorities.
So, it's been allotted to the school education department for school.
That is the main issue, Your Lordship. Lordship, kindly come to page 19. The page 19 clearly says that although they have
Where is the allotment?
Yes,
You are challenging the allotment order.
Yes, Your Lordship, due to some mistake, it has been misplaced. But here,
My Lord, sorry to say they have
You
not
annex that,
furnished.
we'll see.
They have not furnished me with a
Yes.
copy also.
He is not the. He's not a party. Education department is not a party.
yeah, I have made him a party.
Then I should have been furnished with a copy.
I'll give him, Your Lordship.
You annex this and we'll see.
Yes, Lordship.
This is the impugn order. You are challenging the allotment order.
Actually, I'm.
Are you challenging or not?
Yes.
Then
But in my, Your Lordship, in my entire petition that I have mentioned my allotment order. In my entire petition, I mentioned the allotment order, but due to some mistake that has been left out. It is supposed to be in page number 17, Your Lordship. That allotment order, it was supposed to be placed inside page number 17. But by some mistake, it's some
So
other
it's-
document
it's-
that.
it's because of the registry. It's a mistake
No,
of the
no,
registry.
on my part, Your Lordship.
Huh?
On my part.
Then you file a proper petition.
Your Lordship, that may be kindly taken into record and I may be heard.
Pagination is also.
First, you will have to file a proper petition,
But Your
not
Lordship,
rush.
Then tomorrow again, the court will be closed and the court will be closed from the after tomorrow.
Huh?
The court will be closed from the after tomorrow. And now they are constructing boundary walls.
You come to my residence. I'll take up your matter. As in when you file. No worry. First, you file a proper petition, then we'll consider.
Yes, Your Lordship.
Just because you are just placing dropping a petition, and then we'll stay the construction of boundary wall.
Yes, I'm very sorry. Your
We'll have to
Lordship.
understand what
my
your
mistake.
case is.
My mistake.
We don't file proper. We'll take it up day after tomorrow. Or tomorrow, if you file it today, we'll take it up tomorrow.
Yes,
Huh?
Yes, Your Lordship.
Take it back. Mr.
Ketaja.
Ketada, Council for the petitioner. press for withdrawal of this writ petition with the liberty to file fresh, praise aloud. The writ petition stands closed on withdrawal with a liberty as prayed for.
Thank you, Your Lordship.
You record their name also.
May I please?
Yes.
Your Lordship, the petitioner is aggrieved by the non-settlement of the pension.
Yes, obtain instruction.
Letter.
What is your entitlement? What sort of pension? Your husband died?
Yes, sir.
What are the entitlements?
Pension, monthly pension.
Huh?
The increment which.
No, don't mix up. When your husband died, you are the wife. What are your entitlements? You have to figure it out. It's not all the pension. You just simply say pension is not. There are so many things.
I have received other benefits like gratuity on leave.
Huh.
That I have received.
Okay.
The monthly pension.
No, why it has not been processed?
My lord, that regarding that, my lord, that
who has to process?
my lord, this is
Education
ultimately
department.
pensionary benefit, but has to be released from the director audited pension.
No, what they are saying that it has not been processed. Where it is pending?
It is pending in the Department of Education.
Yes, obtain instruction. We'll dispose day after tomorrow.
Yes, sir.
You obtain instruction.
My lord, I'll try.
Not try. You'll have
Because-
to. You have 2 days. Today, tomorrow.
That is, I'll try, my lord. The thing is.
No. We just wanted to know why this has not been processed. What's
Okay.
wrong?
My
What's
lord.
the problem?
It's almost going to be 2 years now.
Not 2 years. More than a year. More than a year.
More than a year.
We'll see. Heard Mr. So-and-so learned consent for the petitioner. Considering that the grievance raised by the petitioner in this application is for immediate process of what pension papers
Pension paper.
in respect of her late husband who was working as
Vice principal.
who died who was working as vice principal
Government has-
under the education department, government of Arunachal Pradesh, and had died when 29/10/2021. 23. Please stop. Comma. No, please stop. Mr. Tagum, T. Tagum, London Education Department is directed to obtain instruction. List the matter on 04/07/2025. You obtain what's wrong. What's the problem? Otherwise, we'll have to direct you to immediately process
My lord.
and to pay.
My lord.
And you find out what are the, dues.
Yes.
What dues there remains.
My lord.
What for this has to process.
Item number 4.
Yes.
Yes, my lord. In this matter, I am challenging impugn order of releasing.
Very difficult. Sir, very difficult. You must be knowing when this about your date of birth recorded in the service book. You are casual, Peter.
Yes, sir.
There is no service book.
There is during the appointment there were no service book.
Where
as
is the
such.
release order?
Release order is at page number annexer 6, annexer 4, 5, annexer 5.
Page 30.
Yes, my.
Yes.
See, he has been released prematurely on attaining.
No, problem is your date of birth is of when? Your date of birth is of.
It is reflected as 11/2/1963. Whereas my actual date of birth is 30.
1978.
Yes, 1978, my lord. Due to my ignorance, my lord, I was not aware of how it was.
What is recorded in your appointment or the service book?
Yes, there is no service book as such, Your Honor. They are simply maintaining a register.
Yes, of
Yes.
course, of course.
So, my lord, during my appointment, I was instructed to join the duty, but I was never.
Where is your appointment?
My lord, there is during that time, my lord.
There's
there
a problem, whole problem.
Yes,
All
my lord. I understand that, my lord.
But once it is recorded, recorded. There's no service book. You have no, appointment order.
My lord, in fact, after coming to know about my.
Anyway, we'll just issue a notice. Can't help it out. It's been 31st March.
Yes, my lord. My lord, in fact, if this.
No, what I'm on interim prayer.
Okay.
You have no interim prayer.
Yes, I have like interim prayer.
Very difficult. You have already been released on 31st March. It's been more than 2 months.
Yes, my lord. My lord, now it is there is likelihood of appointing that post somebody in my.
It's a
my
casual Peter. What's there? It's not a regular job.
Yes, in fact.
So, heard Mr. T. Omo, counsel for the petitioner. Why? Next para, filing this writ petition, the petitioner has put to challenge the order dated, release order dated. We'll say order dated 31/03/2025, issued by the executive engineer, PHE and water supply, the PHE and WS division, Bomdila, whoever. Three casual fitter in the department.
I'm at serial number 2.
Have been released on attaining the release from the establishment, released from the department on attaining the age of, including 3 persons, including the petitioner, have been released on attaining from the establishment on attaining the age of retirement, attaining the age of superannuation. Lister. The Mr. T. Omo, counsel for the petitioner, submits that the petitioner was appointed as casual fitter in the department, whose date of birth is 38/04/1978. However, due to, please stop. The respondents, that considering the relevant records, including the, what you are relying, which certificate?
I'm relying my birth certificate and then other testimonials.
Including the birth certificate. Having considered the date of birth as 11/02/1963, has illegally released the petitioner from the service as casual fitter. Mr. Before his submission, you would lay at one line. The petitioner also prayed for a direction for correction of his date of birth maintained by the department in the employment register. What register this is?
My lord, I think there is register maintained by
the department. Correction of the date of birth register in the register maintained by the department. From 11/11/02/1963 to 30/04/1978. Then you write that. Issue notice returnable by.
My lord,
weeks,
may
3
I
weeks.
kindly
MS.
make one observation, my lord. The
Yes,
pendency.
and as MS Basar, Learned State Council enters appearance and accepts notice on behalf of all the respondents.
Yes, Lord.
No formal notice need be there. No, the issuance of formal notice is dispensed with. Our extra copies be furnished to the learners.
My lord, one small observation. The pendency of this petition may not, the hard, the
Pendency
authority
of
may dispose
the present writ petition
yes, ma'am.
shall not be a bar to
Dispose of the representation dated
dispose of the representation of the petitioner dated
2705.
27/05/2025.
Yes, ma'am. Most obliged.
No, I didn't find adjourn. Adjourn.
My lord, matter may be possible for the timing.
Why?
Man, counsel
Is it-
is appearing before the honorable.
Hello.
He has
My
joined
lord,
for through this.
this is item 7.
Yes,
Yes, my lord, I'm appearing for the petitioner in this matter.
you are half visible.
Oh my God.
Show your
Yes.
face.
I'm so sorry, my lord.
Yes.
Okay, my lord. Yes, my lord. This is section 11 application, my lord, before this honorable court. For
Yes.
appointment of an arbitrator, my lord.
Yes.
Yes, my lord. So, my lord, there were 2 agreements actually in this matter. One with the landowner, there is a JV. And other one is with Suda. That is respond number 1, my lord. My lord, yes, my lord. So the arbitration agreement is there, my lord, in both the agreements, my lord. And therefore, my lord, there is some dispute arose, and because of that, one writ petition was filed by respond number 2 before this honorable court, my lord.
Sir, where are you appearing from?
Delhi, my lord.
Where are you appearing from? Delhi.
Yes, my lord.
Can you come physically?
Yes, my lord.
It's very difficult.
So, my lord,
Otherwise, I'm conscious. This court is conscious that we should dispose of the matter.
yes, my
It's
lord.
been pending for since
So,
two.
my lord, actually, most of the time.
I thought of I'll dispose of the matter, but it's very difficult through the BC.
Okay, my lord. I'm so sorry, my lord,
The-
because
this-
I
this
came
part-
so many times, my lord, before this honorable court physically.
No,
but,
I thought of disposing, but because of you only, it is difficult.
my lord,
It's
my
very
lord,
difficult.
Then, my lord, can we fix for 29th, 8th?
You come, you better come, present physically and argue the matter because.
Yes.
No,
Okay,
if
my
you
lord.
want to take risk, I'm ready.
No, my lord. I don't want to take any risk, my lord. I would love.
I mean, risk in the sense, if there is something I cannot guarantee.
No,
This
my
court
lord.
cannot get any
No, my lord.
guarantee.
I'll be there. So, my lord, I mean, many times I appeared before this honorable court was.
Yes,
something
you have filed the affidavit.
No, my lord, in my petition, after page 41, then is page 63.
No, issue is very simple, sir.
Yes.
There's an agreement, I mean, arbitration clause. I think the matter appears to be arbitrable.
The government is also there. Sudha.
Yes, government, what is the government? Just wait.
Here, madam, earlier UD, standing council, UD and housing was there, madam. That's why madam, we didn't receive the file.
Take all of on this.
On the next
You
day,
know the developments, and every time you cannot make this excuse. Whether land management, UD, PW, whatever.
Yeah, madam, it's written SC, UD and housing, madam. That's why.
Had you not known, then matter is different.
Like
If
person.
you knew.
Take over long back.
Otherwise, it's simple. And you know, Supreme Court is very heavy on it. Honorable Supreme Court is very heavy on it. We cannot afford to keep pending this petition, such type of petition. Within 2 months, 3 months, we'll have to dispose. It's been pending since 2022.
Yes. Otherwise also, I have no issue, but this petition is time bar also.
No, that's why. That's the reason. I know that you'll argue. I know the response will, but the problem is anyway. There's another difficulty.
Please, madam.
Otherwise, this court, I thought I'll dispose of the matter. My lord, basically, my lord.
Anyway, you please come,
Yes,
come
my lord,
here.
the 29th August, my lord, may be fixed, my lord, I'll be there.
Okay. Have you filed the affidavit?
I have not.
If you have any objection, whatever the government has also filed the
Government
affidavit.
file affidavit.
No, my lord, I haven't received any response. I mean, any response from other respondents, my lord, so far as this matter is.
Appears to be.
Yes, the UD has filed.
They have filed.
My lord,
They have filed the affidavit. You get,
Okay, my lord.
how do you have a
Yes, my lord, the local council we have.
here?
Yes, my lord. Actually,
You
he has
asked
been
your,
appointed.
you asked the local council here to collect the affidavit from the government.
Please, my lord. Please,
We'll
sir.
just say,
I-
we'll direct. Huh?
Please, my lord.
Heard Mr.
Abhinav Prakash, my lord.
Avinav Prakash, learned counsel for the petitioner,
216.
and Mr. MS T. Wang, learned state counsel for state respondent, and Mr. G. Tarak for
Respondent number 2.
respondent number. You are private respondent.
Yes, here private.
Respondent number 2. Please stop. Next para. It is said that you have also filed the affidavit.
I have not yet filed.
You are not filing.
I'll ask my client and team.
No.
I have not yet filed.
We'll allow you to file before 29.
Okay.
All right.
Yes.
On or before 29.
Sorry, Karul file.
It is noticed that the state respondents have filed their affidavit in opposition. However, Mr. Prakash, learned counsel for petitioner, submits that he has not received a copy, Mr. In view of above, MS T. Wang, learned state counsel to furnish the copy of the affidavit in opposition while on behalf of the state, and the learned counsel for the petitioner to collect it from the government office, government advocate's office, government advocate office. Mr. Jitar is also, and may also file the affidavit in opposition on or before the next date. On or before 1 week before the next date. 1 week before the next date.
Please, my lord.
List the matter as agreed to by learned counsel for parties. Let this matter be listed on 29th.
29th August.
29 August.
Yes, my lord.
Yes.
July.
No, my lord. 29th August, my lord.
August.
Yes, my lord.
Don't blame us again.
No, my lord.
29/08/2025.
Okay.
Yes.
My lord, maybe this can be disposed of.
Who has to pay?
There's a government of India, my lord. We don't have a budgetary support for this, my lord. This has to be 100% borne by the government of India. And there was earlier they submitted the executed bail, and as per the direction of the ministry, my lord, we verified, and his entitlement is, my lord, although we have raised the maintainability also, that because of time bar, my lord, 5 lakhs around, my lord. This has to be borne by the and paid by the government of India, my lord. Unless there's budgetary support, my lord.
5 lakhs.
Yes, my lord.
He is claiming 33 lakhs.
He's claiming 5, but this is exaggerated. We have verified it, my lord, on as per, since there's an objection raised from the government of India. Entire various districts of the state of Arunachal during those periods were, my lord, 49 lakhs something. Now the entitlement of the petitioners, we work out around 5 lakhs. But that amount we have forwarded to the government of India. Now we don't have a budgetary support for this, my lord. This is since 100% borne by the government of India. So that's why, unfortunately, last occasion also when this matter list, my lord, I raised this point that the latter government of India be made a party, because ultimately they are the person who will make who has to make payment, my lord. I requested my senior
Government of India, there's FCI.
Yes, Miss, my lord. They have to be
Corporation
party.
of India or the Government of India.
Government of India, my lord. This is Government of India, my lord. Government of India, Ministry of Human Resources Development, my lord.
May I just
So-
clarify one thing, my lord. My lord, this entire contract, it's no doubt a central government contract, but they have assigned the state government through a particular department. And that particular department had floated the tender, awarded the work on behalf of the central government. Now, that department has become the agent of the central government, of the concerned ministry. Now, in my writ petition also, I have specifically pleaded that it is the responsibility of the state government department to coordinate between the central ministry and the contractor, and they have to ask for the budget money. We know where we have stated that they have to pay from the state exchequer. Now, when they have acted as a agent and the principal, now it is their responsibility to arrange. How can I go all around the entire India to this thing when they are the person who had tendered, who had awarded the work, and at that relevant point of time, the work was undertaken by the.
What is the tender?
The tender is not, allotment is there.
There was no tender, I guess.
Where is the allotment?
Page 19. This was by the
District Supply
earlier-
Officer.
Yes,
Quantity Commission.
earlier this scheme was executed through the Director of Civil Supplies. Now, this award letter, through this award letter, I was directed to execute the agreement. Accordingly, we did it. And my lord, at page 20, page 20 is a decision taken by the government of Arunachal Pradesh, whereby from 2000, on 21/6/2006, it was decided that henceforth the midday meal scheme shall be routed not through the Director of Civil Supplies, but by the Director of School Education. And accordingly, we have raised the bill at page 21 onwards, Annex 3. Well, this entire records, this is undertaken by the Department of Education, Malad. My respectful submission is, since the tender was floated by the Director of Civil Supplies, award was also made under the approval of the Director of Civil Supplies, and since the scheme has been with stock and barrel, has been taken over from the Director of Civil Supplies to the Department of Education, so they have the entire responsibility. So at this stage, they cannot just shy away. And Malad, since the department are the authority which has floated, awarded, and it is their responsibility to make arrangement. How they make arrangement, that is for them to decide and then do it. And then for that matter, the question of misjoinder does not arise, Madam. Therefore, the plea of the misjoinder is merely an afterthought, Madam. At this instance, they cannot just shy away. They have extracted the work. They have made me work. I had no direct link with the Union Ministry of Education.
Page 42.
My lord.
You have written a letter to the Ministry of Human Resource Development.
My lord, that we
It's
have
not FCI now.
we have written, my
It's not
lord.
the government of India. You have written, it's your duty to get the fund, whatever is there.
My lord, that's
It's
why,
not
my
a
lord,
co-
we have written too, my lord, but
You have agreed. You have agreed that he has supplied.
my lord, that's on record, my lord. Now, this one thing, my lord, we have raised the issue of limitation part also. This has been filed after lapses of 16 years. Now, the one issue after lapses of such 16 years, even writ petition, although it is, my lord, whether it is maintainable or not, this also we have raised, my lord. After 16 years, my lord. The project was executed in year 2005 to
What's
16.
the judgment?
My lord.
Justice. Answer is judgment. Where is the judgment?
My lord.
If you are raising that issue.
My lord, Supreme Court, my lord, it says, my lord, in that case, even writ petition, my lord, if it is filed, my lord, it should be within the limitation prescribed for filing civil suit, my lord. Even in writ petition also, my lord. That is basic ground they have.
Where is the judgment?
My lord, judgment, my lord, unfortunate, my lord.
Why go to the Supreme Court when you are here, when you get in Arunachal Pradesh?
My lord, that is why, my lord, this issue is there, my lord. Ultimately, the government of India.
What is the admitted amount?
Admitted amount is like 5,86,000.
Why don't you pay the admitted amount?
My lord, that we don't have a budgetary support.
No, that's not the lookout. It cannot be. It is you to manage. From where,
Yes,
how you manage, that is not lookout of the petition. You have engaged him. If you are disputing the amount, it may be valid. We don't know. That is subject to what they can do. But at least the admitted amount from where you get, how you get, you have to pay.
My lord, that part.
It's not question of, it's how they will, he's rightly point out, he has rightly submitted. How can he run around?
My lord, I may be granted some more time, my lord. I'll discuss with the authority regarding this aspect, my lord. Because
one thing, limitation.
No,
You
my
get
lord,
whatever
records.
you be happy, whatever they have admitted. We'll direct them to pay.
Yes, my lord. This is my submission.
But,
because as far as limitation is concerned, my lord, just one there has been a continuous course of action. We have raised this bill, and the decision of 2006 came into being. It took some time, and in 2009, the Deputy Director of School Education, West Siang District, Alo, had sent the bill for payment. They for what? This is the for payment. Now, in 2012 also, my lord, they have sought some clarifications from the
2012
also. Now, in 2012 also, the Director of Food and Civil Supplies, they have made the clarifications. And it is the Education Department who has not paid. They have been making regular correspondences.
They should have approached in time, my lord. My respect to sir.
What is the limitation?
Limitation, my lord, says that, my lord, after cause of action, 3 years should be the even for approaching the High Court.
You have raised that.
My lord, I've raised, specifically I have raised, my lord.
Have you filed that?
They have not yet filed.
They have no option but then to raise this technical
Yes,
issue.
my lord.
So you
No, my lord,
file a reply.
preliminary
We'll
objection I've
consider
raised.
that. But you they disputed, we cannot. And at least your other ground were not prima facie satisfied. You will have to pay the admitted amount.
My lord.
Subject to the
Limitation issue, my lord.
technical issues you have raised, you file and reply to that. Otherwise, he may be correct. Or Mr. T. Patilan, counsel for the petitioner, and Mr. T. Tagam, counsel for the
Some time may be given for filing the.
No, we'll say.
No,
Since considering the matter relates to non-payment of outstanding bill amount for the execution of
carriers contract.
Yes.
For
Midday meal
carriers contract.
During the
of,
period
midday
2005
meal.
to
Midday meal.
under midday
Mr.
meal scheme.
The petitioner, the respondent's education department
120.
has filed an affidavit indicating the admitted amount of rupees 5 lakhs and odd. 5 lakhs only.
5 lakhs,
86.
5 lakhs 86,000 only.
Yes.
5 lakhs 86,000.
070.
And also
070.
Raises the maintainability to writ petition on the ground of a limitation list of having considered above, having considered that the respondents have admitted the above amount. Prima facie. No. It would not be a bar for the respondent authorities to release the said amount during the pendency. However, Mr. T. Learned Counsel for the petitioner, Learned Counsel is permitted to, is granted 3 weeks time to file affidavit in reply to the affidavit filed by the respondent, state respondent. We'll just say there will not be a bar. Since there is admission, it's not a bar to payment. We're not directing him to say.
Yes, Malad.
You have admitted, but then you said number one is.
Malad, we don't have a budget. Since this scheme is 100% borne by the
That's
government.
why we're not saying, we're not issuing a mandamus, or we're not.
They have to just recommend to the ministry for
you discuss with them.
Yes, madam. Deeply aware.
I know that you'll not pay.
Malad.
Is not it? But then let us see how good gesture the state has, being a welfare state.
Yeah, in that case, I'll be seeking interest, annual interest. Oblige us.
Yes, I will.
Yes.
I am for respondent number 2 and 4, my lord. I have
Yes.
received instruction in this case, my lord. I pray some more time, my lord, to file affidavit of option.
What is the matter? What is the matter?
Matter, my lord, he is seeking for promotion, my lord.
Okay. You have retired already?
No. Return. I have received the instruction, my lord. I pray some more time.
Enjoy the evening of your life. Why necessary all this? You are responding agriculture department.
My lord. For 2 and
Why you have notified?
2 and 4, my lord. I have received the instruction, my lord. I am praying some time, my lord.
Heard Mr.
K. Lolen.
K. Lolen. There are 2 K. Lolen. You have to identify.
Kirmani Lolen.
Huh?
Kirmani Lolen also.
Kirmani Lolen. Learned Counsel for the petitioner. Next para. Mr. L. Perme, Learned Standing Counsel, Agriculture Department, submits that he has received the instruction. Submits that he has already received the instruction. Mr. Therefore, press for 3 weeks time to bring on record the instruction by an affidavit. Mr. Praise the Lord. List the matter after 3 weeks so as to enable Mr. Permit to Learned Standing Counsel to file the affidavit. As spread. Is spread above. Is spread for.
Your Lordship.
Yes.
Your Lordship, this matter is about illegal land acquisition, Your Lordship, for the Trans-Arunachal highway project, Your Lordship. In connection to this matter, Your Lordship, had already appeared as an appellant, Your Lordship.
Okay. List this matter before any other approvals without me. Okay. Yes.
This Lordship, as observed on earlier previous occasion, Lordship may remand back the matter to the Deputy Commissioner so that petitioner can file an appropriate application before appropriate forum.
Where is the order of the Deputy Commissioner?
Page number 45.
Vacation notice. Yes, what do you say? Let the Deputy Commissioner hear all the parties and pass an appropriate orders by giving them an opportunity.
Lordship, in fact, opportunity was granted, Lordship.
What is there?
But then,
You were given an enough of furnish document evidence to substantiate claim, but you have failed to furnish any during the time of hearing. Yes, during the time of hearing.
However, Lordship, the Deputy Commissioner has passed the order in capacity of Executive Magistrate.
This is a private land.
Yes, Lordship, LPC land.
It's a private land.
Yes, Lordship. I have a land.
It's not a
occupied
government
land. No, it's not a.
Then you
government.
file a suit.
Yes, Lordship, that can
You
be.
file a suit. Order to vacate from the said building within a period of 1 week from the date of issue of this notice of vacation. Even a non-conditional notice. See, how can you evict a person from private land? The eviction is under the Public Premises Act. It's not a public premise.
Lordship,
We'll say, let us do one thing. We'll allow them to file, avail the appropriate remedy within 1 month. If they fail in the 1 month, nothing should be done. And of course, subject to the order passed by the appropriate civil court. All right. 1 month grace period will give her. Right. You cannot evict him. Evict her. It's not a private land.
Lordship, I'll just apprise one thing, Lordship.
Yes.
Lordship, as per Arunachal Pradesh Land Settlement Records Act and Rules, Lordship. Here, Lordship, the revenue officer can evict, Lordship.
Huh?
Can evict, Lordship.
Why? It's if it's from a private land.
Lordship, this is
from a private land.
It's a LPC land, Lordship.
LPC is not it's not a private. It's not an
Lordship,
allotment.
in my humble
Who has given the LPC?
Lordship, Deputy Commissioner. Deputy Commissioner.
Under which law?
Under this act.
Huh?
Under this act and rules, Lordship.
Land
Normally,
and settlement.
Lordship.
Where is the provision that the government land can be given by way of LPC?
No, this is not government land.
It's not a government land. How can
private
you
land.
do that?
Lordship, but my humble understanding would be, Lordship.
Either of you have to file a suit. That's all.
Lordship, that part I completely agree, Lordship. But then this act and rules also will be applicable for the person who are having LPC, Lordship.
LPC is issued under which act? Under which rule? There's a set of guidelines for issuance of LPC of the private land.
That is true.
And this LPC, even if the title is disputed, doesn't confer a title. It's just an evidence of, the proof of the possession. So under the law, the LPC will not create any title. So it's a misnomer and being practiced in the state that once you obtain the LPC, because it's a circumstances in the state that this sort of, I think, has to be resorted to. Otherwise, LPC doesn't create a title. Even if you have a valid LPC, title can be always disputed.
Lordship,
There can be a dispute on the
that
title.
part, Lordship, that part I agree, Lordship. But
So then either of you can file a suit if you are claiming that this land belongs to you.
may I apprise
And
one
DC
thing?
has no authority. It has to be very clear. He may hear it as a deputy commissioner. Whether this position is with whom, whether this has been issued. He can be one of the witness. He can be one of the witness in the civil proceedings.
Lordship, as per 2018, Lordship, under this
Think
act,
about it.
under this act, Lordship, just
But,
apprising, Lordship.
No, I'm clear. Huh?
Just I'm trying to apprise
Rule?
one section of this thing, Lordship. Arunachal Pradesh Second Act 2000, Lordship. The land possession documents issued by the competent authority outside notified forest shall be entitled to be conferred ownership rights on such terms and conditions. Outside the notified forest.
Huh.
Now that land is outside the notified forest and land possession
It's not
documents is
question of
there.
forest now, yeah. Anyway, in that case, I thought we'll dispose of the matter.
Lordship may kindly dispose it of, Lordship.
You are disputing it.
No, I'm not disputing, just like apprising,
So
Lordship.
but this order has to go. In that case, this is order has to go.
Lordship, I agree.
So we'll provide that, we'll give the liberty to the parties to approach the appropriate remedy, right?
Lordship, appropriate forum.
Heard Mr. R. E. Learned counsel for the petitioner, and also heard MS G at Learned Additional Senior Governor for respondent number 1, 2, 3, 1, 2, 3,
4 and 5, Lordship.
4 and 5, and Mr. J. J. Learned counsel for the respondent number 6. Next para. By filing this application, the petitioner has put to challenge the communication, the vacation notice dated 06/01/2024 issued by the Deputy Commissioner from District Magistrate, Lower Siang District, Likabali, whereby the petitioner has been directed to vacate the land, vacate the building. This is a building or what? Who has constructed the building?
No, Lordship, I have constructed the SPT building on my own occupied plot of land.
Vacate from the building within 1 week, within a period of 1 week. And in the event of non-compliance, eviction process shall be carried out by deploying the police force. This stuff. The petitioner, the brief facts of the case, sort of unnecessary details, SHORN, is that she is an old widow. As it was 60 years, having 3 children. and is living alone in the semi-RCC building over the self-acquired plot of land since 2010. Mr. The plot of land is measuring about 250 square meters at Likavali Township. You have constructed the building in 2010.
Yes, Lordship. This is not a RCC building, the semi SPT.
I said semi-RCC. SPT or you said semi-RCC?
Yes, semi RCC.
Semi-RCC. Is it correct? Mr. The land in question has been purchased from one Puneshwar Gogoi for a sum of rupees 11,000 in the year 2010. Yes, not Likavali. At before that, when we said Likavali, at Lipu Market Line Likavali, Lipu 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 Market Line Likavali, huh? Lower Civil District. Mr. It is the contention of the petition that the land of the petitioner is bounded by the plot of land measuring about 940.50 square meter owned by the respondent number 6 in 3 sites. Mr. On the written complaint filed by the respondent number 6 on 29/10/2024. The Deputy Commissioner from District Magistrate Lower Siang District. Before the Deputy Commissioner Lower Siang District, alleging that the petitioner is residing in his plot for which she had already taken a sum of rupees 5 lakhs from the respondent number 6. Very difficult. You straight away denying the receipt of 5 lakhs.
Yes, Lordship. For that, I have already filed an FIR. Matter is under inquiry, Lordship.
You have filed an FIR?
Yes.
Mr. Ingo. No, Mr. The Deputy Commissioner continue, has acted on the complaint of the respondent number 6 by depriving the petitioner from her from her legally owned plot of land and the residence by issuing the impugn order, Mr. Issuing the impugn notice, Mr. Arin Land counsel for the petitioner submits that the Deputy Commissioner Lord Siang District without issuance of proper notice had fixed the matter for hearing on 8/11/2024. Mr. However, due to ill health of the petitioner, she could not attend the hearing. Thereafter, again, the matter was fixed on 26/11/2024. The petitioner, being the genuine owner of the land, had appeared and submitted the sale documents which is evidently, which shows that the plot of land, land in question was purchased from one Sri Ganeshan Gobay on 11/08/20, 2010, list of which has not been properly considered by the Deputy Commissioner. He submits that although no opportunity to place the no opportunity was granted to submit the submits the documents, comma, on the direction to appear, comma, the petition had to appear. However, when the documents, including land sale deed, has not been considered. Therefore, the petitioner was not properly heard in violation of the principle of natural justice. And as such, the impugn order dated so and so, passed by the Deputy Commissioner. No, impugn notice dated, notice of vacation dated 6/12/2024. It is liable to be satisfied and passed. What is your state?
My state is this same matter, Lordship, already Gava has decided the issue, Lordship, that I have annexed, Lordship. That apart, Lordship, he's a non-APST, Lordship. The question of possessing a land does not arise, Lordship. That is another point that I would like to raise.
Before that, MSG at Learned.
And moreover, one more.
Yes, Learned Additional Senior Government Advocate submits that pursuant to the complaint of the complaint filed by the respondent number 6, the Deputy Commissioner as a district magistrate has heard the parties by providing an opportunity heard and provided opportunities to the parties, including the petitioner. Mr. The petitioner was given enough opportunity to furnish documentary evidence to substantiate her claim, but she has failed to furnish any documentary evidence during the time of our hearing. Mr. Therefore, Mr. Having found that the respondent 6 has furnished the documentary evidence in original, including the land position certificate and periodic Khira's Patta, duly issued by the Deputy Commissioner of Damages. And on consideration, have found that the land belongs to the respondent number 6, Mr. Thereby, the impure notice of vacation had to be issued. Mr. And as such, no fault can be attributed to the Deputy Commissioner cum District Magistrate for issuance of such vacation notice, as the petitioner is found to be illegally in occupation of the land of the respondent number 6. That is what Deputy Commissioner has said. Then
one more thing,
Mr. Judge counsel for the respondent submits that the issue has been already settled by the appropriate forum, as by Kaba decision dated
6/5/2019.
6/5/2009.
19.
Kaba. She was also involved.
Yes, she was there.
She was there. I said by Kaba decision dated in the presence of the petitioner. She was present. She was present.
Lordship, there. It is there in the record, Lordship. She was there. She was directed to present her documents, Lordship. In spite of that, she could not produce any documents.
In the Keba.
Paragraph 3.
In the Keba.
Lordship.
In the Keba.
Lordship.
Keba decision.
Lordship.
Where
It's
it
there.
is? Page?
Page 81 of my affidavit in opposition. Paragraph 3, Lordship. Srimati Tilupukon, despite repeated requests from the GMC committee, failed to provide any authentic documents to claim the ownership of the land, whereas Tugu, the complainant, has legal documents
No, she was not present.
to prove.
She has refused to attend. Mr. The petition was, no, Mr. Even during the Keba proceedings, despite several opportunities, neither the petitioner has attended Keba proceedings nor submitted any documents in support of her claim. Mr. Having no alternative, even after the decision of the appropriate forum like Keba in favor of the petitioner, in favor of respondent 6. Come on, since the petitioner was illegally continued to occupy the land, the respondent 6, having no alternative, had to approach the concerned Deputy Commissioner Rest of the concerned deputy commissioner, the deputy commissioner has granted enough opportunity to the petitioner. And she was heard and enough opportunity to substantiate her claim. And after hearing her, the impugn notice, vacation notice has been issued, Mr. Therefore, he submits that there is no illegality in issuance of the impugn vacation notice that is 6/12/2024. As it is now certain that the land belongs to the respondent number 6 and the petitioner is an illegal occupant. Mr. That moreover, Mr. Amorso, Mr. So-and-so, for the submission, the petitioner being a non-local in the state of Arunachal Pradesh doesn't have a right to occupy any land.
And one more thing, Lordship,
And
page,
as such, she
page
has no
87, Lordship.
claim
He has,
right
she has
of-
already taken 5 lakhs and she has already consented to surrender that house, Lordship. She has constructed, Lordship. Page 87.
How, what, under what circumstances?
Lordship, since that house was
Furthermore,
constructed in my
Mr.
plot of land, Lordship.
87,
Lordship, page 87, Lordship.
87.
After the Kaval, Lordship. Annex 3, Lordship.
Anyway, we're not entering into it. All right. No, before that, after that. Before the last paragraph, submission. Mr. Gini also submits that although the petitioner failed to attain the KEBA, after the decision of the KEBA, she has sought for 7 days, 5 days
5 lakhs.
to vacate the land. Please.
For that, already FIR has been filed.
Huh?
Matter is under inquiry, Lordship.
Huh?
For that allegation, already FIR has been
Anyway.
filed. The matter is under inquiry, Lordship.
You are not talking about the payment of 5 lakhs.
Lordship, receipt is there, Lordship. She has received 5 lakhs, Lordship. She has
Oh,
already
but
taken
you-
5 lakhs.
So you have purchased it. According to you have purchased.
No, for that constructed house. But because she has to shift out, since that house was
Where
constructed
it
by
is?
her.
Where it is? Let us see. Where is the receipt?
88, Lordship, annexure.
No witness, nothing.
Received a sum of rupees 5 lakhs only from Sri Tugo being
No,
the
where is
compensation.
the witness? Any witness?
So this is a receipt order, Lordship. And then the page 87 is letter of surrender, Lordship, furnished by herself.
You had one more. The petitioner has no, respondent 6 has paid rupees 5 lakhs to the petitioner, which has been duly acknowledged on 24/10/2019. For the cost of SPT taps shop oblique stall construction under the LPC duly already obtained by the respondent number 6. No, over the land. Stall construction over the land, huh? Just, you add in his submission, we'll see it, huh? That you will. Are you clear? Any confusion? Next, rejoining is a submission. Mr. Ari, land counsel for the petition submits them. So far as the payment and receipt of ₹5 lakhs is concerned, the petitioner has lodged an FIR.
My rejoinder, page number 6106. My rejoinder to the affidavit filed by
Lodge an FIR on
29/11/2024.
29/11/2024, which is pending investigation.
Yes, pending investigation.
investigation. Therefore, no reliance can be placed on the payment of the amount for the cost of the structure of the building of the petition.
Not lordship, pending investigation, pending inquiry, lordship, not registered, not yet registered.
Okay, pending inquiry. Next paragraph. Consider the submissions of counsel to the parties. And also, where is the reports as
More about
where
lots
is
of the
materials available on record.
Kaba decision which the respondent has reported to is not a right forum to conduct the Kaba. This is
Anyway,
not
I will not say anything. Admittedly, this LPC, LPC is of the 940.50. The land falls under within this.
Your Lordship, for that I have in my petition para 3, I have categorically stated that the land which is under my possession is not within the allotted LPC land of the respondent number 6.
No, we'll say the plot of land on which a plot of land measuring 250 square meters.
Yes, Lord.
On which the petitioner has constructed semi-RCC building at Lipu Market Line, Likavali, Lower Sing District. And the land measuring 940.50 square meters owned by the respondent number 6 appears to be in the same plot of same area. List. The respondent number 6 has the valid land possession certificate and appears to have periodic KIRA's KHIRAJ duly issued by the Deputy Commissioner of Lower Senen District and the Demaji District. The claim of the petitioner where is your sale deed? You have the sale deed
Yes, Lordship.
from Puneshwar.
Puneshwar.
where it is. Agreement for handover.
Phase
41.
Anyway, no, it's not
41.
41. 41 is a translated copy.
The issue, the dispute appears to have been referred to the where is it? Keba decision? Keba decision.
Keba decision.
No, no. Where is the Keba decision?
81, page 81.
81.
Yes.
What is by Keba decision? By whom?
A joint meeting of Gamburas of Arunachal Pradesh and Assam counterpart was held on dated 6th May
Okay.
2019
Next minute.
under the agent
The
of
issue, huh? The dispute between the petitioner and the respondent 6 appears to have been settled by a joint meeting of Gamburas of Arunachal Pradesh and Assam counterpart on 6/09/05/2019 at Likavali under the auspices of Galo Missing Coordination Committee for by settling the matter amicably.
Without the presence of petitioner.
List of the petitioner appears to have not present in the said meeting oblique Keba, although it indicates that that she was provided repeated opportunities and she was repeatedly requested to appear before the committee and to provide authentic documents to substantiate her claim of ownership over the land in question. Mr. Next paragraph. It is also seen that the respondent 6 has paid. No, please continue. The petition also appears to have sought for a 5 days time to vacate the land after the decision of the committee, aforesaid committee. Mr. However, she continues to reside on the land. Mr. Next paragraph. Pursuant to the complaint made by the respondent number 6, the deputy commissioner has taken up the matter, thereby conducted a hearing on 2 days i.e. 18/11/2024 and 26/11/2024. Mr. It is by which it is indicated that the petitioner was provided with an opportunity of not only hearing but also to furnish documents to substantiate his claim over the land in question. Mr. Next paragraph. Having concluded that the petitioner has failed to furnish any documents in support of her claim, and also having found that the respondent has the documents, including the land possession certificate issued by the Deputy Commissioner Likavali and the periodic Khiraz Patta by the Deputy Commissioner Demaji from Assam. The petitioner is directed to vacate the land within 1 week. However, and in the event of non-compliance, the administration would carry out eviction process. Having considered the submissions and materials available on record, I'm of the considered view that the petitioner is originally a resident of the state of Assam. State of Assam.
No, I am originally,
Fukon,
I have
Fukon.
been residing there at Likavali since time
No,
ago.
originally from the state of Assam, and who is residing at Likavali. Since when? Since 2010.
No, before that also, Lord.
Where you were before that? Which place?
At that point of time, Lordship is well aware of that, the fact that the Assam ownership boundary was.
Who has who is since 2010 by allegedly purchase a plot of land from one Guneshwar.
Yes, Guneshwar Gogoi.
Guneshwar Gogoi.
Yes.
Please stop. The respondents has also the respondent is owning a plot of land measuring 940.50 square meter, having the LPC land possession certificate and Gires Patta, periodic Gires Patta. Mr. Although the committee consists of Gaubura of state of Arunachal Pradesh, and the Gaubura consists of Gauburas from Likavali and the missing autonomous council what? Missing.
No, it's a Galo
Consists of
coordination.
missing community.
Yes,
Missing community under the authorship of Galo
missing coordination committee.
Galo Missing Coordination Committee has taken up the matter for amicable settlement, and accordingly was settle the dispute between the petitioner and respondent. Nevertheless, the decision was not adhered to. And as the same is not an legally recognized forum, as the same was under the auspices of the committee, although consists of governors of both this from Arunachal Pradesh and the Assam. Mr. Next paragraph. On consideration of the impugned vacation notice issued by the Deputy Commissioner cum District Magistrate, comma, I find that the order for vacation on the ground that the respondent number 6 is there. Is having the valid documents in support of his claim over the land in question as a deputy commissioner. Mr. Hauber, to carry out the eviction process by deploying the police force would not be permissible under the law, in as much as it is evidently a private plot of land between the two private individuals, which cannot be said to be public premises under the law. Mr. Having considered above, comma, since the dispute appears to have not been settled through the legally recognized forum, either by of Keva proceedings or any other proceedings, the appropriate proceedings which have the authority and jurisdiction to decide the land dispute. It would be appropriate to relegate the parties to approach the appropriate remedy under the law. Mr. Next paragraph. In view of the facts and circumstances and the discussion briefly made here in above, without going into the legality or validity of the impugned vacation notice issued by the Deputy Commissioner cum District Magistrate, Lower Siang District, and the claims and counterclaims of the parties come up. The interest of justice would serve, comma, if the parties are directed to avail the appropriate remedy as may be permissible under the law. Mr. Accordingly, the writ petition stands closed with a liberty to the parties to approach the appropriate remedy to avail the appropriate remedy under the law within a period of 1 month from today. 1 month from today.
Lordship,
1 month from today. Please.
this impugned order.
Needless to observe that on the petition of the parties, either of the parties, the appropriate forum, appropriate forum oblique civil court would take up the matter and pass orders in accordance with the law, including the injunction, if any. Please, till such time the impugn order, impugn notice of vacation, impugn vacation notice that is 1601 1/2/2024 shall not be given effect to. For 1 month.
After that again, Lordship, this,
Huh?
Lordship may kindly set aside this, since this shall not any bearing effect. Okay.
I know that you will not go back. I mean, you will not approach. If we set aside this, you will remain like that. Then the dispute will remain. I want that it should be resolved this way, that way.
Deeply offended.
You may go, you may send somebody, because it takes time, no? Would they take the file? No? Yes,
Yeah, Your Lordship, state have to file reply.
yes, affidavit.
Yes, Your Lordship, we have not received the instruction, Your Lordship, or otherwise comment, so some more time may be needed,
I
Your
think
Lordship.
this is third time. So you will not file affidavit unless the matter gets older by 2 years or 3 years. Is it the rule? Is it the rule? And we will not insist for ask for the instruction. Yes, madam, is it a rule?
Yes. Yes, wait, please.
I mean, so and so land counsel for the petitioner. On the prayer of Mr. P. Pangu, Land State Council, further 4 weeks' time is granted to file affidavit in office.
Obelix, Your Lordship.
Non-payment of pension.
Yes.
Non-payment of pension.
Lordship, non-payment of pension is due to Lordship, his age, overage has not been condoned because of that, Lordship. It has gone to the government, Lordship.
Non-payment of
Pension.
pension.
My lord. Respondent number 1 was supposed to file affidavit.
Affidavit.
My lord. He is sitting over.
Who is respondent number 1? Respondent number 5. Apart from respondent
5
number
is director audit and
who is
pension.
who is respondent number 5? You are appearing.
I'm appearing, Lord.
He is the concerned authority.
No, he is director audit and pension.
Audit
But he is saying that since there is no condonation of
Age.
so therefore they have a difficulty to pay the pension.
Okay.
And now file is with
And other has to file in that case. Who is the concerned department?
Concerned department.
transport man.
You have to
Transport.
file.
From the secretary level, it has to file the Lordship, the call me up.
Give some more time. You file it.
This is
Pension department may be correct. Unless it is done, how can they
But-
just issue? They cannot condone it. It is to the department. It is to be by the department only.
My lord.
Yes, heard, Mr. Last chance.
Yes, Lordship.
Learned counsel for the petitioner. Learned counsel.
This
for
may
the-
be my lord.
Huh?
The final last chance, my lord.
No, final. Last chance was given.
Second time, this is third time, my lord. Kindly see the order. Endeavor has to be made to dispose of the matter.
Yeah.
Lordship, I have communicated, they called me up yesterday only that they want to discuss something on this, Lordship. So, of course, we will be filing in 2 weeks' time. So, the department has,
Yes.
Before that,
This
also
code
previous
only.
order.
Lordship,
So can we dispose it of?
No, Lordship, the department has sent the, unless the age is condemned, Lordship.
You discuss, we will not say anything. If you
Lord-
want to file, I mean, it's up to you. We have just given. Obtain instruction will say. No further adjournment on
Yes.
next day.
Yes,
We
Lordship.
do that, whatever you want to do, do it.
Yes,
Because we
Lordship.
cannot keep granting last chance.
Yes, Lordship.
We are making, would be,
No, Lord, understood, Lordship. Of course, this is.
yes,
Pensionary-
Mr. Ketam, learn counsel for the petitioner. Further, no, a week's time is granted. A week's time is granted to MSG at learned additional senior government advocate to take, to option instruction. This stuff. It is made clear that no further adjournments will be granted on the next day. It would not look nice to, I mean, look proper to record that third last. Last is last, what's there? So with the understanding that she will take a call. Whatever you want to do it, do it.
Yes, Lordship.
So pension will dissuade that we'll have to, we cannot afford to keep it pending.
Please.
File your last.
Yes, I'm.
Yes.
Hampering some more time, my lord, to file application.
What is the matter?
My lord, I have been issuing
Pending
work
bill, my lord.
order.
Disputed, but disputed, my lord, in this case, my lord.
This shall not be a bar for responding to examine the claimant and release the payment. Have you examined?
My lord,
Have you examined?
no, my lord, I have to
Then
take
why,
instruction.
without examining, how can you say that it's disputed?
On the record of the writ petition itself, my lord, this is on the record of this writ petition, my lord, this is disputed, I believe, my lord.
What is the amount?
Amount three work. One is around 5 lakhs.
Let them file. If we find that if it is admitted, we'll direct them whether they have a money or not. If it is disputed, go to the civil court. Heard Mr. O. Dugong, learned counsel for the petitioner. On the prayer of MS. Who is one? You are one.
No, my lord, I am for 2, 4, 5, 6, and 7, my lord.
MSK, K. Wang, learned
For 1 and
State Council and Mr. L. Perme, learned Standing Council,
my lord.
Power Department. Further 2 weeks' time is granted to file their respective affidavits. Huh? This is clearly indicating the amount claimed by the petitioner is admitted or disputed.
All.
That's all is the issue. You don't have to have a Ramayana and all Mahabharata. Yes.
My lord, I have, I'm for the petitioner, I have to apply rejoinder. Rejoinder application.
Okay. Last time also,
I need some more time.
this is I think 4th time. On the prayer of Mr. So-and-so, learned counsel for the landscape for the petition further.
Summer vacation.
The 2 weeks' time is granted to file affidavit reply as a last chance. This is 5th time.
For me, please, Your Honor.
Yes.
So now on the last date, that is on 6/5/2025. On the last date, that is on 6/5/2025, this honorable court had noted that if the affidavits are not filed by the respondents by 30th of May 2025, then this case will proceed ex parte against them.
Yes.
Till date, more than 1 month has passed and we've not received any affidavits yet, Your Honor.
So respondent number 2 is private respond is notice is served.
Yes, Your Honor.
Private, who is for private respondent?
No one is appearing, Your Honor.
Yes.
Well, notice to private respondent, my lord, was served to our office, my lord.
You have served it. Yes,
Yes,
sir.
my lord, I placed that on record, my lord.
But what about you, affidavit?
My lord,
You have promoted the junior.
Your Honor, if Your Honor will kindly peruse the last date, last order dated 6/5/2025.
No, it's for promotion, it should be very difficult, sir. Madam?
This honorable court had noted that the matter will proceed ex parte against the respondent number 8.
1 and 272, respondent number 4, deliver this writ petition before the expiry against the
Para-
expert considered for notice in this case.
Para 4.
Hmm.
And thereby on the last paragraph, it was noted that if the respondent number 1 and 2 and 2 to 7 fail to file their
Yes,
respective
I have seen
affidavits
it.
on or before 35/2025.
But
So,
then next date, it is on the concern of you have taken a time thereafter. 4/6,
my-
you have taken a time.
my prayer is
It was
that, Your
fixed
Honor,
on 04/06.
yes, Your Honor, my humble prayer
This
is that
reference
this
shall
matter may
proceed
be
expire against whether considering the fact that notice in this case was, then on 4/6 it was fixed. Then you have taken a time on the prayer of Mr. Mugwam Pertin Lan so and so with consent or other said it was spread. So what I was trying to say?
my humble prayer is that this matter may be fixed for final hearing, Your Honor.
Okay. Heard MS
T.Y. Bhutia.
T.Y. Bhutia, learned counsel for the petitioner. In view of the order, which was that order so and so, so and so? Order dated
6/5/2025.
before 4/6.
Yes, Your Honor.
25?
6/5/2025.
Just use the mic.
6/5/2025.
6/5/2025. The writ petition is admitted for hearing. List after 3 weeks.
DP of Land.
And heard so and so. MS so and so. Heard Mr. You are one.
Yes.
One. You are keeping silence. Why? Today is a day for not talking or speaking out.
No, Your Lordship. One, Your Lordship, we are not filing, Your Lordship.
You are not filing. Why?
Who responded on one, Your Lordship?
Who is respondent number 1? Okay. So Chief Secretary has, let us Chief Secretary ask you not to speak anything.
No, Your Lordship, it's not like that, Your
It's,
Lordship.
it's a very, it may adverse to you.
No, Your Lordship.
We have heard that if you speak more, the lifespan decrease. So is it the belief you are having? Anyway, it's on lighter note. Don't take it seriously.
May I please?
Yes.
Madam.
Complaint.
No, Malab, one, I don't know why they are so adamant. The simple direction of this honorable court was that 12 persons, the in solution.
Where is the direction?
Yes, Lordship, can you see the page? Lordship will 14, page 14 is the operative portion. Paragraph 13.
This respondent, special respondent is directed by the directed.
Grant solution and interest upon the compensation which has already been fixed to be paid by petitioner for acquiring his land for establishing a border outpost in the land of petitioner in terms of this petition disposed of. Malad, the direction was the deputy commissioner. Malad. Deputy commissioner is not the authority who will pay, Malad. But the deputy commissioner is the authority who has to forward this letter to the ITV.
Similar issue for entitled to solution is pending.
Yes, ma'am.
Malad, in fact, 2 petitions were filed, Malad. One for payment of compensation and the other for payment of 100% solution. Compensation part that has been paid, my lord. Thereafter, that solution basing on the Mihin Laling case that was stayed by the Honorable Supreme Court. Our stand here is that since that has been stayed, we have not forwarded. Now that matter is still pending. We have filed a review. The state has filed a review petition also because this
Against the order.
against this because
Against this order.
yes.
Yes.
Because there was a finding that the Mihin Laling case also has been dismissed, my lord. The writ appeals mentioned in paragraph 12 of this order. In fact, that was by the NHPC that was dismissed, my lord, by NHIDC.
So
that the finding that this has the Mihin Laling case has been dismissed, that is also pending for review, my lord. The writ appeals, my lord.
This one.
Yes, my lord. Review and against this very order also we have
No,
filed.
have you filed any appeal against this?
No, we have filed
You have filed a review.
Review.
Review was rejected.
No, my lord. Review is pending, my lord.
My lord, just after because of this contempt petition, they have now filed the review.
No, otherwise it's been stayed by the Supreme Court.
Yes.
No,
Division.
my lord, that facts we are not denying, my lord. The contempt is only for the fact that the respondent tree has failed to act upon the order, my lord.
Is directed by the venomous to grant solution and interest upon the position.
But the respondent number 3 is the not authority who will ultimately grant, my lord. He has to process the file. That's the thing, my lord.
No, there is no direction against him. There is no direction to process.
No, pay
It's only
solution.
payment.
Payment of solution, my lord.
When
For that,
on the basis of these judgment,
Yes.
Laling and this thing, right?
yes.
If it's a state by the Honorable Supreme Court and it is seen that this was in this case, the state they have said that this has been dismissed. Right?
Yes.
It's a this order would not have been passed also.
My lord,
The solution is concerned.
my lord, the facts, solution, my lord, that my lord, matter would have been different, my lord.
What is the direction in favor of the respondent number 3?
To pay solution, that's the direction, my
Yeah.
lord. 12%.
So when the solution cannot be paid now, in view of the judgment of the Supreme Court, I mean the interim order of the Supreme Court, was the question of compliance, payment. It's only for payment.
Yes.
When it cannot be paid now, right now. That's why I think they have rightly filed a review. Review has to be considered. On
And in the
prime facie, sir. Because the order is based on the submission of the, of course, they may not have that, I mean, the instruction was not been placed at that point of time, appears to be. They say this has been all dismissed in the SLP, by the Supreme Court. NSID, ECL, Gita Mehu and all those things.
Yes.
In other matter, it has been stayed. So, because that SLP was dismissed, therefore this was granted.
Yes, my lord.
Had it been brought before the court that it has been stayed, it would not have passed this order. I think for grant of solution.
Yes, my lord. My lord, in the meantime,
You fight it out in the review. There's no violation as such.
my lord, in the meantime,
So we'll close it.
yes, alleged contemner also has been transferred. We have filed.
Again, you have to plead another the new inquiry. You will remain, but the present incumbent has to be implemented.
Yes. That,
What do you will close it? Fight it out in a review.
that can also be done, my lord, but if the file notings and all those are seen, my lord,
So we'll
the matter would.
So we'll keep it pending.
Yes, my lord.
We'll keep it pending. We'll not say anything.
Yes.
Because it's a contempt proceeding, it's a altogether different proceedings.
Yes.
So we'll not comment on all these things. We'll just keep it pending.
Yes.
Heard Mr. So and so learned counsel for the, you have you filed the affidavit?
Yes, we have filed the affidavit and also an additional affidavit saying that we have, this present incumbent has been transferred out.
So you implead
Yes,
if
ma'am.
it's and Mr. And learned counsel for the Alice Contempt, Mr. On the prayer of Mr. We'll just adjourn it.
Yes, ma'am.
To you, granting you to take
After 4
appropriate
years.
steps. The prayer of Mr. Peter for learned counsel for the Peter for learned counsel for the 4 weeks time is granted to take appropriate steps for implement,
Yes.
if any.
Much obliged.
Obliged, madam.
Number 25.
To finish prosecuting.
You also hear the
No
Respon-
affidavit.
respondents 7 and 8. Not
Yes,
fi- not
with
five.
7 and 8.
CBI and ED.
Yes,
Well, I'm for the CBI.
most important. CBI and ED, most important. What is the matter?
Matter is
no-
the APCS. APCS exam which conducted by the APCS. And the petitioner is the requested to the school court for
Okay,
re-exam.
anyway, this is
Yes,
for
conducting.
orders today. Huh?
Yes.
Heard Mr. Ex-Giati learned counsel for the petitioner on the prayer of Mr. M. Kato learned DSGI. Further, 3 weeks time is granted to file affidavit.
Number 26.
My lord, the state response, they have filed affidavit and we have filed rejoinder also.
My lord, I need 2 weeks time. Our affidavit is ready, my lord. I am for the private respondent.
Private. Okay, heard Mr. Peter learned counsel for the press. The state has already filed their MS and also MS T1 learned state counsel for state respondent, who has already filed the affidavit on the prayer of Mr. BP learned counsel for respondent number
5.
5. Further 2 weeks time, 3 weeks time is granted for.
My lord, this matter at least urgent.
2 weeks.
Yes.
Yes. Obliged.
28.
Yes, I'm I'm taking some more time, my lord, to file affidavit in opposition.
Yes, stay.
Yes, my lord.
Heard Mr. BP learned counsel for the petition. On the prayer of Mr. L. Perman, standing counsel agriculture department, further 3 weeks time is granted to file affidavit.
Okay.
My lord, interim order may be continued. my lord.
Interim order first, let's continue.
Obliged.
Debtor mining.
And I'm for the
David service, we'll see. Non appears for the petitioner on call. Mr. K. M. Kato London DSA is present. Edward's report, Edward's service report in respect of respondent number 2.
2 man.
This after 4 weeks.
With the list.
Edward service report. Heard Mr. So-and-so learned counsel for the petition and you are for? 4.
Respondent number 5.
5. P. Pangu State Council for State Respondent and for Respondent number 5. Edward service report in respect of Respondent number 7. List after 4 weeks.
Will I say lordship?
Number 32.
But it appears petitioners are not interested in the case, my lord. They have not taken any service of notice upon private respondent.
Yes.
I don't, I may be allowed to,
withdraw.
no. Some more time to.
Further 7 days time is granted to Mr. T. Omo, learned counsel for the petitioners to take steps for service of notice upon respondent 5 and 6.
What's up, man?
Mr. B. Pitch, learned standing counsel, RB is present. You have filed the affidavit.
Yes, ma'am.
Okay.
Obliged.
Is there anything to be adjudicated upon?
No, my lord.
Rejection of my.
That's what I'm saying. Have you gone through the affidavit?
No, I received yesterday.
Okay. Yes.
Obliged.
May I, my lord?
Yes.
My lord, this is service matter, my lord,
Yes,
which
I
is-
know this is service matter.
Which is my,
What sort of service matter?
Your Honor, Your Honor, actually, my senior counsel, Mr. B, already strictly not allowed me to submission this.
What? Is strictly prohibited. He has restricted you to argue the matter.
Yes, sir.
We'll record it and we'll pass orders.
My lord, at least
So,
2 days may be given.
Actually, there's no merit.
yeah.
How can they say that you should be, you are LDC.
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 You should be, you are seeking the designation as tax assistant. It's all the job of the department, madam. How can you? With 6 and 7? Responsible section.
Finance department.
Why you are not filing? 6 and 7, yes.
Yeah, Lordship,
They have been implemented later.
yes, received instruction, Lordship, but I need some clarification from them.
But ensure that on next time when you appear, not only for adjournment, to argue the matter. All right. And come prepared with the argument. You have to place the facts first and then law, if any. Law will take care, don't worry. But first you argue the facts. And as a lawyer, you're supposed to place the law also. And if there's a difficulty in the placing the law, will rather the court will assist you. Don't just come like that. All right. Heard MS so-and-so, learned counsel, appearing on behalf of Mr. B. Arun.
Yes. my-
What problem he has?
Due to medical problem.
For the petition, learned counsel for the petitioner submits that her senior, Mr. Arun, B. Arun, Mr. Arun has some medical problem. Therefore, matter be adjourned to 2 weeks. Mr. Estafin, learned counsel to learned senior government advocate is also granted time to file affidavit on behalf of respondents 6 and 7. Finance department. Only finance, 6
Finance.
and 7.
Finance.
Who appears to have been implemented. Subsequently implemented in this matter. There's a reason, that's why they might have been implemented.
Yes.
Okay.
So you have been brought in, Colin.
My lord,
You have been Colin.
my lord,
Where you were?
my lord, I'm in ICDS. In past, my lord, before come to the facts of the case.
No, no, where you were in this morning?
My lord,
In the morning.
my lord, I got little bit late. And my lord, I have been informed by the, my lord, council of this, my lord, department that he is having some personal problem at the hospital. Therefore, he could not, he is ready to take the adjournment. So with that, since I have already consented and just honestly reported purpose, my lord, matter is not ready. Since my lord, I have consented, therefore, my lord, since I
Let
have.
us see, what is the origin order? This is the second writ petition. This is the second round of late.
Yes, my lord.
Writ petition, yes.
The first one is.
Order
only,
is
my lord,
page 16.
My lord. So far the first one is cancelled, my lord. That was only seeking for disposals of the representation, and that representation was disposed. But my lord, before that, my lord, whether the government is ready, my lord, that because since, my lord, I have been informed by the
Government is ready.
government council.
Are you ready?
Is ready?
Yes,
Not
yeah,
ready.
Your Lordship, I have gone through the affidavit, Your Lordship.
Huh?
Yes, Your Lordship, I've gone through the affidavit, Your Lordship. I've gone through, Your Lordship.
Yes. Are you ready or not? Are you ready or not?
Okay, Your Lordship. The petitioner. Actually, here in this matter, Advocate Yomi was appearing.
Affidavit on behalf of respondent number 1, 2, and 3. Joint Secretary.
Yes. My lord, the
Yes,
respondents
120, Your
are,
Lordship.
yes, respondents are limited to 1, 2, 3. Now, my lord, since the government is also ready, my lord, it will take, my lord, the hardly, my lord, 15 minutes to complete, my lord. So
I have read this, there is nothing.
my
You are appointed as UDC for 1 month. And from
No,
time to
ma'am.
time, your services were extended, right? And thereafter, your post as a UDC appears to have been upgraded as a welfare officer with a higher pay scale. So once you are upgraded and once you are appointed as a after the thing, after you have been allowed to serve as a UDC, there's no UDC as such. There's no question of reversion as such. It was purely a contract. It cannot be said to be your post, right?
No, my lord.
So be happy with the welfare officer getting higher pay scale. There's no question of reversion.
My lord, basically
cannot
what
be
my,
reverted.
my lord. Basically, my lord, what,
We'll hear you at 2 o'clock. Perhaps there's no case.
my lord, I will try to demonstrate, my lord. There is a case, my lord.
There is a
And-
case. There is a case.
My lord.
You'll have to show that how you are appointed as a UDC. Was there any advertisement?
Of
Was
course,
there
ma'am.
any sanction force?
My lord, to that extent, I admitted. Honestly, to that extent, I admitted that they that was in the contract force. But what basically my grievances was that they are in the same department. There was a ICDS and the ICPS. Now the difference between the two scheme is ICPS, Integrated Child Development Scheme, has been adopted by the government of Arunachal Pradesh. Therefore, those who are working in this ICDS cell, their services are regularized by the department. Therefore, there is a scope to be regular in the post.
But then first you have to establish that whether you have a right to be reverted back to UDC, which is no longer there, because you have been appointed for 1 year and extension from time to time. There's
That
nothing.
is the contention of the
Just because you are afraid, you are anticipating.
I am ready to demonstrate that, my lord, still the post of the UDC in the ICDS is there, my lord.
Even if it's there, we cannot. You cannot be allowed to.
I will try it too, my lord. I will try it to convince this honorable court, my lord.
This can.
I have resumed to, my lord, convince this honorable.
At 2, you also prepare.
Okay, your lordship.
What he said is, he has a post, he should be reverted back. At 2.
May I please, Lordship, in item 29, I was supposed to appear for the petitioner. So
Non-appears.
non-appear is there.
You just said.
Give your blessing.
Matter pertaining to principal seat, IAS Civil number 213 of 2025.
May I please your lordship?
Yes.
My lord, first of all, I'm sorry for troubling your lordship, my lord, for this matter.
No.
My lord.
What's there? No question of troubling. Yes.
My lord, on 26/22, my lord, I'm going to background of the case, my lord. An advertisement made for 17 posts of Anganwadi worker and helper. In response to that, we have filed our applications. Thereafter, my lord, on 26/12/2024, second advertisement made again for filling up of 47 posts, including the post for which we have applied for. My lord, then they were not calling us, my lord, coming to know that we may not be called. We went to the office of the CDPO. They told that, yes, we are thinking about it. But being, my lord, quite doubtful about that, we have filed this WPC, my lord.
No. What about the selection? The interview is over.
Yes, no. My interview is over, my lord. Kindly see.
So if interview is over, what can we do now?
No, my lord, yes, my lord. Kindly see the interview, my lord, at page
Just come to page 12.
13.
Page 12,
13.
page 12, page
Page 13, my lord.
page 12, page 12.
Maybe, my lord, some.
Order of this court.
Yes, yes, my lord, of this court, my lord, yes. My lord, your lordship, your order, they may be allowed, they may allow, they have misused this may, my lord, and not, had it been shall, my lord, perhaps they would have been allowed to participate in the selection process. Because your lordship was not sure on that day whether interview is over or not. That's why your lordship used the word may in place of shall, perhaps, my lord. Because your lordship was not sure on that day whether interview is over or not. That's why there is a rider, my lord, that if the selection process has not been already over, my lord, then my lord come to page, next page, my lord, 13, my lord. Kindly see, it is hereby notified that applicants for Anganwadi worker and helper are directed to appear in the interview as per schedule below.
No, that's right. Now, what can we do?
My lord, kindly see, my lord, on only 48 hours notice, my lord, which is not allowed in any system, my lord. 48 hours notice, my lord, they have 126.6, they fixed for the interview for workers on post, my lord. And my post is, my lord, kindly turn to page 20, my lord. At serial number 172, my lord. That is the post number 50, Borkhetri Barni post, my lord. Only for that, my lord, we are before your lordship, my lord. Not for any other, only one post among all others, my lord. We are not against any other post. What happened, my lord? As per the instruction, my lord, at paragraph 8, my lord, I have mentioned the CDPO holding the post is not transferred, my lord, and new CDPO is coming. That's why, my lord, suddenly, in a very hurried manner, very illegally, with 48 hours notice, my lord, that too, without any wide circulation, only in office, my lord, they have called for the interview. And we went to the on 26th also. I have mentioned specifically in the petition, my lord, they gave no proper reply. Whether we are not called for, in spite of the Honorable Court's order, they could not give any proper reply, my lord. So, my
When
lord,
did you approach?
Yes,
Have you filed any application to
my
allow
lord,
you to?
that did not allow anything, my lord. On verbally, we have went to the office, we have met them, we have talked to them, but they are not giving any proper reply, my lord. Not
So what do you want now?
My lord, only that, my lord.
What do you want?
Only one thing that, my lord, the selection result of that particular one post may not be declared without the leave of the Honorable Court, and we are allowed to participate in the process only, my lord. Only one for that post only, my lord. Not no any other post, my lord. Out of 47 posts, they may go, my lord. But
Yeah,
the
but
result of
this application is for modification of the order. How can there is a question of modification?
my lord, my
If
lord,
they have wrongly interpreted the order, on the basis of that, how can we modify the order?
my lord, to the extent only that they remain, we may be allowed to, we shall be this may be made shall, my lord, and till then, my lord, result may not be declared only for that one post only.
We'll issue notice. We'll issue notice in this, and we'll tell them not to finalize the result.
Yes, my lord.
Yes.
Only to that, my lord.
Lordship,
Yes, yes.
uh,
We'll issue notice.
okay, Lordship.
In the meantime, don't declare the result. Don't finalize it till later table date.
Finalized, Lordship, we are not having any updated instruction, Lordship, because on 20.
That's why, because admittedly they have not been allowed, and your date
Lordship,
of
there is nothing on
your
record
date
to show that
your
they have approached, Lordship. This is there. Kindly note it.
so
Lordship.
anyway, we'll see till return. We'll just say that don't declare the result, right? Heard,
Of
Mr.
that particular Anganwadi center, Lordship.
Only, my lord, only one post of that.
What is particular? What is the
Not one
Anganwadi
post,
center?
Lordship, of that particular Anganwadi center.
Worker post is one. One post.
Heard, Mr.
A.K.
A.K.
Talukdar.
Talukdar, learned counsel for the applicant, and also heard MS M. Bhattacharya, learned state counsel for the opposite party respondents, public respondents. The filing this application, the petitioner, the applicant has sought for modification of the order dated 11/04/2025 passed by this court in WPC 149 of 2025. List of this court. Next para. By an order dated 11/04/2025. Having considered the submissions of learned counsel for the parties, directed the respondents, directed that the respondent authorities may allow the petitioner to participate in the selection process pursuant to the advertisement dated 26/12/2024.
My lord,
If the selection process has not been already over by then, for the post of Anganwadi worker,
yes, my lord, Anganwadi worker.
Anganwadi worker against
Against, my lord, a particular center.
number 50 Barketri Barni -2 Anganwadi Center under Paschim Nalbari ICDS project. List of next para. It is the contention of the council for the applicant that despite several approaches, the petitioner has not been petitioners or petitioner only one.
Two, my lord,
Petitioner-
two.
Lordship, there is nothing on record. He have approached Lordship.
applicants have not been allowed to participate in the interview, which was settled on 27/06/2025. List of on the other hand, next para, MS Bhattacharya learned state council submits that there is nothing on record to show that the petitioners have approached, the applicants have approached the, there are two applicants.
Two applicants, my lord.
Have approached the
There is no
authority
application of them, Lordship.
to allow them to,
After the order was passed by your Lordship.
after the order dated 11/04/2020 passed by this court. Mr. Issue notice returnable by 4 weeks. 4 weeks. It will be 4 weeks. 4 weeks.
My lord.
Mr. Since MS Bhattacharya enters appearance and accept notice on behalf of all the respondent, no formal notice need be served. However, extra copies be furnished to the land council for the response. Next, where having considered the this court on 11/4/2025 has directed the respondent authorities to allow the petitioner to participate in the interview pursuant to the above pursuant to the advertisement dated 26/12/2024 for Anganwadi so and so, worker in respect of so and so, the same place, if the selection process has not been completed back then, process completion has not completed back then, and considering that the interview was supposed to interview has conducted on 27/06/2025, till the returnable that no results shall be declared in terms of the
interview held on
pursuant to the interview conducted on 27/06/2025 in respect of the so and so Anganwadi center, same name of them. This after 4 weeks. That's all.
My lord, only a small thing, my lord. The date maybe, my lord, should be advertisement dated 206 of 2022, my lord. There are two advertisements. We have applied for earlier one. And second one is 26/12/2024, my lord.
No, no, that we have deliberated. Once that has been already cancelled,
my lord.
was the question of 2022.
Lord.
There was a fresh advertisement.
Yes, my lord.
Yes.
And
That's
we
why,
have,
that's the reason that we directed you, the response to allow the petition to participate in the present transfer, the advertisement.
my lord, what
That we
happened,
have considered, sir. Thank
my
you.
lord, my lord, what happened, my lord? We
Not
applied
22,
for-
it is, that will be deliberated upon, sir.
my lord.
24,
we applied,
24.
we applied for, my lord. For
See,
the,
this interview has been conducted and the selection process was in pursuant to the advertisement 2024.
Yes,
not
Lord.
22.
My lord.
Yes.
But we applied, my lord. We
Okay, thank you.
My obliged.
Deeply obliged, Lord.
I passed out.
Obliged.
Yes.
Yes, my lord.
50%.
Now, my lord, here in this case, what is only the crux point to justify it? I am trying to justify it before the lordship was only why, despite of the officer, child welfare officer, but I prefer the LDC in this ICDS department. Now, my lord, the fact is, when I was appointed in the 2007, and while my service was running for 8 years, in the years 2015, I have been promoted to this child welfare officer. Now, differences between these two is child welfare officer is under the ICPS, my lord, integrated child protection scheme, and the previous one is child development scheme. Now, in a child development scheme, ICDS, there at least, my lord, honestly, I admitted that I am in the contract force. But despite of the, by virtue of service in the law.
No, this is Mission Batsale.
My lord, now this has been renamed in the years 2023. Mission Vatsalya scheme.
Batsalia scheme, yes.
Mission Vatsalya scheme. Now, no more, my lord, this ICDS, my lord. Now, differences is only, my lord. My grievances is where I have been dragged as an officer, posted as an officer under this scheme, my lord. There is no certainty in my future service because this is the central scheme. It is sponsored by the central. 80% is sponsored by the scheme, which can be withdrawn by the state at any time, my lord. At the same time, in the previous scheme, this has already been adopted by the, my lord, government of Arunachal Pradesh. Therefore, this is under the child social welfare child development department is taking after this. Meaning, my lord, person who are serving in this ICDS scheme have, my lord, opportunity to regularize their service in future, my lord. Therefore, my lord, my grievances is only that I have been posted to the SAS scheme where there is a, my lord, no certainty because the central can withdraw at any time. Therefore, my representation, I have ventilated my grievances that I may be returned back to the same post as a LDC. Despite that I am in the officer, but there is no certainty. But that has been rejected by the department, my lord. Now, only the issue before this honorable court to ascertain is whether the department has accepted that the Mission Vatsalya scheme, Ardwell's integrated child development, can be withdrawn by the central government at any time or not, my lord. This question is my lord, this affirm reply only, my lord, in my para 7 is the main point that this service can be.
See, your appointment is not on regular basis.
My lord, that I
As
admit.
a UDC, it was a contractual. They were so generous that you have been allowed to continue for so many years.
My lord.
And then you have been allowed to, you have been again appointed. It's a new, fresh appointment. What's the question of reverting back?
My lord. But
The moment you contractual appointment with extension and then it severed the, you accepted the new post, the two contractual basis, it may be a different scheme.
Exactly, my lord.
Then you have no right.
Now, my question is only, my lord, that the subsequent post, there is no possibility, there is
So
no
that's,
future.
That's your ill luck. How can you
Therefore-
do that? What is your right? That this course may not be, there may not be uncertainty for regulation. There is a chances of which you have been earlier appointed, which you have already severed the ties. You have no connection with that post now. It's not a regular or it's not a deputation. It's not
Neither
it's
this
a
is,
press appointment.
neither, that point, my lord, I am definitely agreed with that, my lord. Neither this is the deputation, nor this is the regular. But my lord, since both the post is regulated under the, my lord, same Department of the Social Welfare and Child Development. Therefore, my lord, my grievances point is only, my lord, that if the present post is withdrawn by the department, my lord, my possibility to regularize and get appointment, my possibility to opportunity to, my lord, place DPC before the concerned authority will be, my lord, completely deprived.
You are no longer there. How come question of DPC?
That is why, my lord, my grievances is that
you cannot be reverted back. When there is no post, when you have not any lien to that post, how can you be reverted?
My lord, to this aspect, my lord, the points are still there, my lord.
Where is the last order of the court?
My lord, to this respect, my lord, I will take to the lordship, may kindly reply filed by the respondent of the para 8, where they have admitted that this can be, my lord, rather this can be extended or this can be, my lord, withdrawn in the future, my lord. Therefore, my lord, my submission, what I am trying to justify is that my opportunity to, at least opportunity to getting regular in the department has been deprived by the department by putting me into this Vatsalya scheme, which has no certainty, which has not been adopted by the department. And that is why my prayer is that I may be allowed to go back to the, my lord, that.
There is no question of going back. You are appointed for certain period and then extended. Now, the moment you are appointed as a child welfare officer or welfare officer under the scheme.
Under the scheme, and both the scheme is, my lord, run by the same department, same department of the.
It's not your choice.
Government.
What is your right? You have accepted, and suddenly you find that there may not be uncertainty in the post. Let me go back. You have a right over do you have a right over that UDC post? There is no lien. It's not a question of deputation.
My lord, I am repeated, my lord, that part, my lord, honestly, my service was not regular. But had I been in that post, my lord, I could have been regularized.
It is, however made clear, it is the prerogative of the employer as to where the employer would like to place the employee. In other words, the direction of control disposal may not be constituted by the authority as a direction considered as favorably.
Therefore, my lord, the government has admitted that the present Vatsalya vision is the, my lord, this may be withdrawn by the central government at any.
Why then withdrawal, why not concern? What's there? Yes.
Your Lordship, in this matter, Your Lordship, the petitioner appointment order, you stated that the appointment are purely on contractual basis, which will not confer on them any right to claim over the post for regular appointment, Your Lordship, and so there is no such provision to promote contractor service holder, Your Lordship. And here, Your Lordship, Your Lordship, in our affidavit, Your Lordship, and the petitioner, Your Lordship.
Okay, heard Mr. Seymour, the learned counsel for the. Ready? Heard Mr. Seymour, the learned counsel for the petitioner, and also heard MS P. Pango, learned state counsel for the state respondents. No private respondent.
No.
Mr. Next paragraph. No, challenge made in this writ petition is to the order dated 02/03/2023 passed by the Director, Women and Child Development, Government of Arunachal Pradesh. Page 26, huh? Order number 7, so page 26. Whereby, in pursuance of the order of this court, dated 09/12/2022, in WPC number 480 of 2022, the representation of the petitioner is disposed of, thereby rejecting the claim of the petitioner to revert him back to the post of UDC in the Department of Women and Child Development. List of the grievance is for reverting him back to the post of UDC in which he was appointed on contract basis under the Social Welfare, Women and Child Development, Government of Arunachal Pradesh, for a period of 1 year, for a period of 1 month. From the post of Child Development, Child Welfare Officer, Welfare Officer.
Child Welfare Officer.
Under the observation home and special home. Under the scheme of what?
Under the scheme of my lord, Mission Vatsalya scheme. Now, also will my lord, ICDS.
Mission
Vatsalya scheme.
Vatsalya scheme within bracket. Formerly, no, also ICDS and what? CS?
ICDS and ICPS. Child Protection and Child Development. Integrated Child Development Scheme and Integrated Child Protection Scheme. Difference is P and D, madam.
As well, ICPS/CPS, bracket close. A centrally sponsored scheme. List of next para. The next para. Briefly put, huh? Come on. the case of the petitioner is that he was appointed as UDC on contract basis initially for a period of 1 month by an order dated 12/03/2007, and his service as a contractual UDC has been extended from time to time. Mr. Thereafter, by the order dated 10/03/2024, the petitioner was appointed as welfare officer. Well, the
In page 20, Mal.
20?
Page 20. It's type out copy. The original copy is in page 90.
No. 10/03/2024, nah? Huh? Thereafter, (2014), huh? The petitioner was appointed as welfare officer under juvenile home for a period of 12 months, which has been extended from time to time. It is the contents of the petitioner that since the initial appointment of the petitioner is on the substantive post of UDC and allowed to continue by extending his service, and thereafter appointed as welfare officer. And under the scheme of, under the Mission Bachelor scheme, the petitioner may be reverted back to his original post of UDC in the department as the service of the petitioner as welfare officer under the scheme, but a Mission Bachelor scheme is uncertain.
Uncertain.
As there is likelihood of, and there is no likelihood of regularization in future or the continuance of the scheme further. Mr. Next para. Mr. C. Modi, Learned Counsel for the petitioner, submits that the petitioner, although was appointed on contract basis at UDC, was originally in the ICDS scheme, which has been adopted by the state government in the Department of Women and Child Social Welfare, Women and Child Development, Government of Arunachal Pradesh, and the Mission Bachelor scheme is purely a centrally sponsored scheme, wherein the petitioner has been subsequently allowed to work as welfare officer. Therefore, there's a uncertainty in the service prospect of the petitioner as the post of UDC in which the petitioner was appointed is under the state government, and the welfare officer under which the petitioner is presently serving is purely under the central government, centrally sponsored scheme, which may be discontinued anytime, which would affect the future prospect of being regularized in the service. And as such, the petitioner may be directed to revert back to the post of UDC, where there is a likelihood of consideration for regularization in future by the department. Mr. MS P. Pango, on the other hand, submits that the petitioner was appointed as UDC on contract basis only for 1 month, and thereafter only for thereafter. The service of petitioner was extended from time to time. The petitioner subsequently appointed as welfare officer under it's a new scheme or what?
My lord, same scheme, but the name has been, my lord, changed.
Has been appointed. Have I said? Officer and allowed to serve at juvenile home Pasigat on contractual basis under the scheme. Under the same scheme, under the same scheme. Mr. The petitioner has joined as welfare officer on his own volition, and on such acceptance of the service of welfare officer, the appointment, contractual appointments, appointment as UDC gets severed, SEVERED. She submits that there is no provision of DPC for considering promotion or regulation of contractual staff, as the petitioner has been appointed purely on contractual basis under the scheme, either as UDC or welfare officer. Therefore, question of reverting the petitioner to the post of UDC, which is no longer in existence, after which has no relation with the petition, who is no longer existent after the appointment of petition as welfare officer under the scheme. Mr. She further submits that the service conditions for all the contractual posts, either as UDC or welfare officer, or for that matter, any other post, are same when there is no question, there is no question of regulation. List of. She submits that in view of the above, the respondent authority has rightly rejected the prior petition by the impugn order dated 02/03/2024. And as such, writ petition is liable to be dismissed. Next paragraph. Consider the submissions of learned counsel for the parties. Users and a due consideration has been extended to the submissions of learned counsel for the parties, also perish the reports. List of admittedly, next paragraph, the petitioner was appointed as petitioner was initially appointed as UDC on contractual basis for 1 month from 01/03/2007 to 31/03/2027. 2007 at a fixed monthly salary of monthly fixed salary in juvenile observation camp, special home Pasigat, by the order dated 12/03/2007. His service on contractual basis was extended from time to time. Mr. Thereafter, while the petitioner was serving as UDC on contractual basis, the UDC in the said juvenile home was changed to welfare officer with higher monthly salary on contractual basis, and thereafter extended from time to time. Who is and the petitioner, thereby the petitioner, and consequent to which the petitioner is still serving. You are still serving. You are still serving.
My lord.
Which the petitioner is still serving as welfare officer. List of. It is noted that the petitioner was appointed as UDC on contractual basis under ICPS, ICDS.
RCDS.
ICPS or ICDS?
RCDS.
ICDS.
Mal.
Centrally sponsored scheme which stated to have been adopted by the state government.
Well,
List of the ICPS oblique CPS schemes have been now renamed as Mission Vatsalya Scheme,
Vatsalya.
which is one of the centrally sponsored scheme implemented by the Department of Women and Child Development in society mode as per the scheme guidelines and the scheme, as per the guidelines of the scheme, as per the guidelines, please stop. The engagement of manpower in the under the schemes are purely on contractual basis. Please stop. Next para. The records reveals that the petitioner, the engagement of the petitioner, not records reveal, huh? It is evident from the initial appointment of the petitioner as UDC under the in the department that he has been appointed as on contractual basis, purely on contractual basis with a monthly, with a consolidated fixed pay. List of. It also provides that the appointment is purely on contract basis, which will not confer any right to claim over the post for regular appointment. List of. The this has been re-designated. UDC has been re-designated. Re-designated.
No, madam.
No, they said so in their affidavit. In their affidavit, they are saying that it's re-designated. Upgraded. It also appears that the post of UDC in the actual ICPS oblique ICDS, IPS has been upgraded to welfare officer with enhanced salary, enhanced fixed salary, which is now renamed as Mission Vatsalya Scheme, a purely a centrally sponsored scheme. Mr. Essentially, the petitioner is seeking reversion from the post of welfare officer to the UDC, as he apprehends that his service may not be regularized or discontinued, and anticipated that the post of UDC may be regularized in future. Christoph. to continue, to which this court has considered in this court is of the view that since the since the petitioner has accepted the post of, was appointed as UDC on contractual basis, and the post UDC has been upgraded to the post of upgraded as welfare officer under the scheme, and the scheme having been and the scheme of appointment under the guidelines of the scheme is on contractual basis, the petitioner would not have any right to claim for reversion in view of the fact that the post has already appears to have been upgraded as welfare officer. List of does the contention cannot be accepted. Mr. Even if the post of UDC in the department has a scope of a regulation, the petitioner would not have any right, as the appointment itself is on contractual basis for a period of 1 month, although extended from time to time. And thereafter, the post itself has been upgraded to the post of welfare officer under the scheme. List of having considered above, and in view of the having considered above, and the facts that the petitioner was appointed on contractual basis as UDC and the post having been upgraded to welfare officer, in which the petitioner has been allowed to continue under the scheme, under the central government scheme, as per the scheme of engagement and messages in the engagement of mentors in the guidelines. This court finds no fault. This court finds no ground to interfere with the order dated 02/03/2023 passed by the Director of Women and Child Development, Government of Arunachal Pradesh, and no relief can be granted to the petitioner to revert to the post of UDC. Accordingly, writ petition stands dismissed. And dismissed, being devoid of merit.
All right.
Post made easy.
Obliged, Your Lordship.
Sorry,